Many times, people come over and ask, when is the best time for me to file a trademark application? And I usually say, if you have a mark that is a name, logo, or any other kind of trademark that is associated with your brand, and you have a bona fide intent to use that mark in the future in commerce, then you should always find a way to file a trademark application. Now understand that as a trademark applicant, sometimes your brand is not ready for an immediate launch with evidence of use for a 1A in use application. But like I said, if you have a bona fide intent to use the applied for mark in commerce, a 1B intent to use trademark application is the route for you. This filing basis allows you to secure your trademark before using it in commerce. Hey guys, this is Salam Malhotra, and today I'm gonna give you a little bit of a step-by-step guide to help you navigate the process and protect your brand. Now, what are the differences between a 1A and a 1B filing basis? A trademark application process usually starts with determining the correct filing basis. A filing basis is, for lack of a better term, the basis upon which the trademark applicant files their application at the United States Patent and Trademark Office. The applicant's filing basis, alongside its priority filing date, is a vital part of your mark's examination at the USPTO. The filing basis determines if the mark's owner claims ownership through actual use, a bona fide intent to use, a foreign application based, or an international registration basis through a foreign registration certificate. 1A and 1B are the two most common ways to file trademark applications at the USPTO. The main difference between the two is if the use in commerce is currently happening, or does the owner, have a bona fide intent to use the mark in commerce shortly. If the initial filing is a 1A actual use application, the trademark owner will be required to file evidence of use in commerce. This is where we come to, what if the trademark is currently not being used in commerce, but will be used soon? This is where a 1B intent to use trademark application comes into play. If you want to register your mark before actually using it in commerce, a 1B intent to use application can be an excellent filing basis. It enables you to secure your brand and reserve the right to use it in the future without having to prove current usage. This can be particularly useful for businesses still in the planning stages or not yet ready to launch their product or service, but you've honed in on what your brand is going to be. You've honed in on that logo, you've honed in on your name, and you've honed in on a few more things. It could be products or services. But that bona fide intent must be an actual intent. So it's important to know that you must use the trademark in commerce within a certain time frame or risk losing the registration. A 1B filing basis comes with extra steps, although examination process at the USPTO is same as any other filing basis. Examining attorney will conduct a thorough search to determine if there's any reason to reject your application. Your trademark will be published on the official gazette as long as there are no conflicts. But for your trademark to be actually registered, you must submit a statement of use and a proof of the mark's usage in commerce. Before filing for a 1B intent to use application, it is always important to conduct a thorough trademark search. This can be done through the USPTO database or with the help of a trademark attorney. It's essential to ensure that your trademark is unique and not likely to confuse with existing trademarks in your industry. Failing to conduct a thorough search and review can make your brand vulnerable to legal actions from competitors. Your competitors would have you believe that brand protection only applies to large enterprises, but that is far from the truth. Next step, you file the intent to use application with the USPTO once you've conducted a thorough trademark search and determine that your desired trademark is available. This application requires detailed information about your brand and intended use of the trademark. During the trademark application process, you must specify the filing basis for the classes of goods and services mentioned. In this case, you will file under the 1B intent to use basis. Providing precise and comprehensive information is crucial to prevent any delays or potential application rejection. The USPTO will review your application and may request additional information or clarification before approving your trademark registration. If your 1B intent to use trademark application is approved by the USPTO, you will receive a notice of allowance. This is a significant milestone in the trademark registration process. This means that your trademark has been accepted for registration. However, you're not quite there yet. You must still provide proof of use before your trademark can be officially registered. Usually, you have 6 months from the date of notice of allowance to file a statement of use. And the statement of use must include evidence that your trademark is being used in commerce. This evidence can include things like invoices showing you have sold products or services under your trademark, advertisements that use your trademark, documentation of your website or social media presence of your trademark. Your trademark application will be abandoned if you fail to file a statement of use within 6 months of the notice of allowance. You will then need to start the trademark registration process over again. Prompt action is necessary to avoid complications upon receiving a notice of allowance. Now, if you're not ready yet to use your trademark in commerce and can't provide that proof, you can always file for an extension of time to provide this evidence. USPTO allows you up to 5 extensions to filing a statement of use, but each comes with a $125 per class filing fee. Remember when I said that the process has a few extra steps? These are the extra steps that I was talking about. So if you have filed a trademark application using the 1B intent to use filing basis for 3 classes, the appropriate filing fee for an extension to a statement of use will be $375. Once your statement of use is accepted, your trademark will be officially registered with the USPTO. You should always appreciate the risks associated with an improperly filed trademark application. Hiring a trademark lawyer for brand development, enforcement, and prosecution matters is essential. If you need assistance with a trademark application or other trademark issues, please book a consultation with Drishti Law by going to www.drishtilaw.com or call us at 773-234-1139. This is Sal Malhotra. Thanks for watching.